Good morning, guys. Today we are going to study about the collegium and the topic of collegium and appointment. Last time we studied about the economy. Today I am going to take polity. So again, this is Rao IAS, August month, polity section. So collegium and appointment, judiciary topic, appointment. The primary source of this article is the Hindu, and secondary source is the Indian Express. Supreme Court Collegium under the Chief Justice of India, that is D.Y. Chandrachud, has quietly and transparently streamlined the appointment process of the judges to the constitutional courts, while adding the depth to mix of merit and seniority in the judicial rank through a selection procedure which involves meaningful discussion and assessment of candidate in judicial acumen. So the criticism that was raised against the judges was that there is not a procedure of appointment of judges, and judges kind of favor other judges who work under them, and a Hindi saying goes that bhai bhatijawad is going on in the senior judges. So the Chief Justice has devised a formula quietly without telling public. Then deft mix of merit and seniority both will be taken care while accessing the candidates. The appointment and transfer of judges in Indian higher judiciary, including the Supreme Court and High Courts, have always been a subject to scrutiny and debate. Have always been a subject of intense scrutiny and debate. The collegial system, which is based on recommendation by a group of senior judges led by CJI, has been predominant mode of appointments to the higher judiciary since 1990s. While the collegial system has been praised for ensuring independence and expertise of the judiciary, it has also faced criticism for lack of transparency and accountability. This article basically aims to analyze the collegial system of India, examining its strengths and weaknesses, and exploring the reforms to improve the system effectively and accountability. Exploring the potential reform to improve the system's effectiveness and accountability. So, why the procedure to appoint these judges to higher judiciary is important? The procedure to appoint judges to the higher judiciary is important in India for several reasons. First is separation of power. One of the fundamental principles of Indian Constitution is separation of power between the three branches of the government, that is legislature, executive and judiciary. The judiciary, as an independent and impartial institution, acts as a check on powers of the executive and legislature. The appointment of judges through a transparent, objective process ensures judiciary remains independent, free from any external influence. Second is quality of judges. The appointment of competent and qualified judges is crucial for maintaining the quality and integrity of judiciary. A rigorous and transparent appointment helps to ensure that only most deserving candidates are selected for judicial positions. Third is public confidence. Appointment of judges through a transparent process helps maintain public confidence in judiciary. While the appointment process is perceived as fair and unbiased, it enhances the credibility of judiciary and its decisions. Fourth one is accountability. The appointment process also ensures accountability of judges. If a judge is found to be unfit for the position, he or she can be removed through a due process of law. So we understand that procedure to appoint higher judiciary is important in India, as it helps ensure the independence, quality, accountability and credibility of the judiciary, which is crucial for upholding rule of law and protecting rights of the citizens. We will look what Constitution says about the appointment. It's important constitutional provision regarding the appointment of Supreme Court judges. First is appointment. Article 124 subclause 2 says that every judge of the Supreme Court shall be appointed by the President under warrant under his appointment. For the appointment of judges to the higher judiciary, Article 124 subclause 2 says that every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal. Second is the resignation. Article 124 Subclause 2, subclause A says that a judge may by written for resignation. Article 124 subclause 2 clause 2 subclause A says that a judge may by writing under his hand addressed to the president resign. A judge by writing under his hand addressed to the president resign his office. Third is removal. Article 124 clause 4 says that a judge of the Supreme Court shall not be removed from his office except by the order of president passed after the address by each house of the parliament, supported by majority of total membership of the house and by majority of not less than 2/3 of the members of that house present and voting, has to be presented to the president in the same session for such removal on the ground of proved misbehavior or incapacity. So if someone asks what are the reasons for hired judiciary judges to be expelled, and that the reason would be proved misbehavior or incapacity. Third, the constitution says about the oath. Oath is article 124 clause 6. A person appointed as judge of Supreme Court shall make and subscribe before the president or some person appointed on behalf by him an oath or affirmation according to the form set for the purpose of third schedule. So third schedule records the oath of the Supreme Court or Higher Court. Fourth is bar on practicing. Article 124 clause 7 says that a person who has held the office of judge of SC shall not plead or act in any court or before any authority within the territory of India. So clearly constitution doesn't tell about how the appointment goes. Okay, it doesn't talk about collegium system. So how come this system came? The collegium system has evolved by the way of several enactments and judicial pronouncements. Initially, the appointment of judges to the Supreme Court and higher courts has been mandated in Article 124 clause 2 and 270 clause 1 of the Constitution respectively. The provision provides that the power to appoint the judges vests to the President in consultation with the CJI. For Supreme Court, in consultation with the CJI, the Governor of the concerned state and Chief Justice of the concerned High Court for High Court appointments. Previously, the inclusion of President in consultation of CJI was for namesake, and the appointment to the higher judiciary was a prerogative of executive. So there were changes introduced to the first judge's case. The unfettered power in the hands of executive was challenged in Union of India versus Sankal Chand Himmatlal said 1977, where SC observed that the term consultation, Article 221 clause 1, should be interpreted by reading in real, substantive, effective consultation based on full and proper material placed before the Chief Justice by the government. Then several years later, first judge's case came in SP Gupta versus Union of India 1981. First judge's case, the majority opined that judicial independence is a part of basic structure of the Constitution. However, it was held that the view of the CJY in appointments and transfer is non-determinative, highlighting that executive primacy. The court held that consultation in Article 217 clause 1 does not mean concurrence. It also made clear that the role of CJI is merely consultative and the final decision rests with the government. Second judge's case, the Supreme Court Advocates on Record Association versus Union of India 1993. It was ruled that consultation in Constitution connotates concurrence and held that CJI has primacy in appointment and transfer, that his power was held to be unique, singular and primal. Further, it was stated that the opinion of CJI is not on his own but of the collegium consisting of CJI and next two senior judges in line. Third judge's case, a comprehensive working of the collegium was unanimously clarified by the SC in Re-President Reference 1998, which is also known as third judge's case. As per the ruling, collegium would consist CJI and four senior judges in the line for SC, and CJI 2 senior judges in the line for Chief Justice and 2 senior judges in line for High Courts. Now, the government in 2014 came up with law which was known as ANJAL. In 2014, the Constitution was amended through 99th Constitutional Amendment Act. It provided for the National Judicial Appointment Commission for appointment and transfer of High Court judges and appointment of Supreme Court judges. Composition: CGI plus 2 senior most judges of SC, Law Minister, and 2 eminent persons was held violative of separation of power. The executive would dominate over judiciary in matters of appointment, impinged upon the independence of judiciary, violation of basic structure. However, the collegium system India has come under attack for several reasons. Here are some specific instances that highlight the criticism of collegium system. First is lack of transparency. The decision of the collegium is published on website of Supreme Court but does not reveal methodology or reason provided for transfer and promotion of judges, ground to select senior lawyers for appointment of judges of Supreme Court and High Court. In 2018, 4 senior judges of the Supreme Court publicly criticized the collegium system for lack of transparency in appointment of judges. The judges held a press conference and claimed that allocation of cases by the collegium was arbitrary and opaque. This also raised concern about lack of transparency in appointment of judges to the higher judiciary. Second is allegations of nepotism. Collegium system has been accused of nepotism and favoritism in the appointment of judges. In 2017, a controversy erupted when collegium recommended the appointment of Justice K.M. Joseph to the Supreme Court. The government returned the recommendation. It was alleged that Justice Joseph's appointment was blocked due to ruling against the government in a case of president's rule in Uttarakhand. Third is lack of diversity. Collegium system also been criticized for lack of diversity in appointment of judges. In 2018, it was revealed that there were no judges from scheduled castes and scheduled tribes in Supreme Court. This led to call for collegium system to be more inclusive in its appointment process. Delay in appointments is another reason. The collegium system has been criticized for causing delays in appointment of judges. In 2013, vacancy in High Court stood 37%, 406 posts vacant out of sanctioned 1098. Critics blame collegium system for delay in appointment of judges to fill these vacancies. Lack of accountability. The collegium system has been accused of lack of accountability in the appointment of judges. In 2019, Supreme Court collegium recommended appointment of 2 judges who were facing sexual harassment. This led to public outcry, with critics claiming the collegium was not taking allegations seriously and was not being held accountable for its decisions. Merits of collegium. So we have talked what's wrong with collegium. Now we will talk about the merits of collegium system. It ensures independence of judiciary as mandated by Article 50 from interference of the executive. Views of SC and HC judges are taken in writing. Prevalence of majority opinion favors the democratic process of appointment. Reservation of 2 judges of collegium taken seriously halts the appointment process for a doubtful candidate. So they have to pass by 4-1. There cannot be 3-2 majority to appoint a judge or to transfer it. Fourth, it allows talented lawyers from the bar to be appointed as judges of High Court and Supreme Court. Now, how to improve this? A clear appointment policy should be adopted, minimizing human discretion. Collegium should be transparent regarding the furnishing reason, seniority or merit. Higher judiciary should diversify collegium by including women, minority and civic society groups. Older judges with shorter tenure is often ineffective. Collegium should have permanent secretariat and minutes of the meeting should be subjected to RTI. Collegium should accept the application for appointment as followed by UK. Supreme Court collegium's quiet transparency is driving a change. Since early this year, collegium resolutions have embraced transparency. They have publicly laid bare the requirement for candidates in the zone of consideration for appointment of top courts and high courts. Quality of judgment. Of primary concern for the collegium is the quality of judgments of the candidate. For this judgments are circulated among the members of the collegium well in advance. The Center for Research and Planning of the Supreme Court appears to be compilation of relevant background material to assist the collegium. There is also Judgment Evaluation Committee, which goes through the judicial work of the candidates with a fine-tooth comb. Judges are graded with a very receiving and outstanding grade. This procedure of circulating judgment, prospective candidates making an objective assessment of their relative merit, was introduced for the first time in collegium meeting in September 26 last year. Justice Dipankar Datta's name was the first to be cleared by Supreme Court appointment by this collegium in this manner. While recommending the appointment to the Supreme Court, collegium has taken into consideration following aspects: the seniority of Chief Justices and senior puisne judges in their respective parent High Court, as well as overall seniority of the High Court judges, the merit, performance and integrity of judges under the consideration, the need to ensure diversity and inclusion in the Supreme Court. Diversity and inclusion refer to a representation of High Courts which are not represented inadequately represented in Supreme Court. Appointment of a person from marginalized, backward segments of the society, gender diversity and representation of the minorities. So this completes the article of your appointment of judges.